Thanks.
Good morning, sir.
Hi, how are you?
Good. We're here for your preliminary hearing today. So we're going to get started with that. Okay.
Okay.
Good morning. I'm Parole Officer Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Verity Stephen number 359597. Today is November 26, 2024. This hearing is being conducted via video at the BOPP Central Office and the Carl Robinson Correctional Institution. This is a public hearing and public access to this hearing is available via video live stream. Can you please state for me your full name and DOC inmate number for the record?
Stephen Verity, 359597.
This is a preliminary hearing, which has three purposes under Connecticut law. It's to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show that there is probable cause to believe you violated one or more conditions of your parole, but do not find probable cause, I'll reinstate your parole, which is release you and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge, state your PO is written against you. I will review and identify exhibits that are filed for the record. You will then have an opportunity to address the issue of probable cause and the severity of the allegation. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure right now?
No.
Okay. You have important rights today. The right to have an attorney present. Do you want to continue without counsel?
Yeah.
You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yeah, I believe she came and signed a paper with me.
Yes. It should be that packet of information, like saying what you're here for.
I believe so. I didn't get any copies of it though.
Well, do you want to continue with the hearing still?
Yeah, I can continue with it.
Okay. You have a right to submit evidence in support of your case. At this hearing, the right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge. The state appeal is written against you and the information underlying each charge. Charge 1, under Obeyal laws, obedience to the law. Your charging officer reported on 11/10/24. You're involved in a theft incident at Walmart in Naugatuck, Connecticut. Upon Naugatuck police officer arrival, is found you had worked together with an accomplice to steal approximately 30 items from the store and attempted to leave the store without them. During this investigation, with them. During this investigation, you're found to be in possession of approximately $360 worth of items that were not paid for when leaving the store. You were subsequently arrested by Naugatuck Police Department in charge of larceny 6, conspiracy to commit larceny 6. Based on this, you are in direct violation of PCS condition of bail laws, obedience to the law. And the state has filed the following exhibits that are pre-marked for identification purposes. As Exhibit A is CT remand to custody, B is CT signed conditions of parole, C notice of parole violation, D parole violation report, E is state of Connecticut judicial branch documents, and F is the Naugatuck police report. Did you receive the notice of parole violation report, and those other documents I marked, and did you review them?
I never received them.
Okay, and you said you do want to continue with the hearing though?
This is just a preliminary hearing, right?
Yeah.
And then I get another hearing, right? Or something like that?
Yeah.
So I was supposed to have a lawyer, for, I guess, I don't know if it was for both or for one, but I think,
Well, you weren't eligible for the one for the public defender, so you'd have to obtain your own attorney.
Okay. So I can continue with this one and then obviously the next one, right?
Yeah.
Okay.
Yeah. So do you want to continue with this prelim?
Okay.
Okay.
Yes.
All right. So we have no witnesses today. So now is your opportunity to respond to the parole violation charged against you. However, remember that you may remain silent. Would you like to speak in regards to this charge? If you do, I ask you to swear you and under oath first.
Speak about what? I'm sorry.
You want to speak about regarding the violation that you're in on what I just read about the arrest?
Like my side of it, or?
It's up to you if you want to speak on it. Because if you do, well, just raise your right hand for me. I'm going to swear you in under oath. You solemnly swear, solemnly affirm, as the case may be, that evidence you shall give to in this case shall be the truth, the whole truth, and nothing but the truth to help you God without penalty of perjury?
Yes.
All right, so yeah, so regards to that charge that I read that you're currently in here for, do you want to say anything in regards to that charge?
That I know I made a mistake, obviously. I know I was guilty for it. And
All right, so I appreciate your statement. So what I'm going to do next is I'm going to announce my findings. So I do make a finding of probable cause on that charge. One, obey all laws, obedience to the law based on the evidence and testimony that was presented, and that is exhibits B, E, and F. And I do find the acts are serious enough to warrant revocation. After you should be detained while you wait for your revocation hearing. So what's going to happen is you're going to go to court. You're going to get these charges disposed. When they're disposed, we bring you back, and then we determine if there's a violation or not. And then during this time, if you want to get your attorney or hire an attorney to be for the rev hearing, you can do that.
okay.
Okay, so you're all set for today, and I'll see you when those charges are disposed.
So once those are disposed, my lawyer's supposed to get them dropped on the 2nd.
Okay, but if it happens, whatever happens in court, your officer is gonna know what happens in court, and then they're gonna let us know. And then I bring you back for your rev hearing.
Okay, and I'll meet with you again?
Yes.
Okay.
Okay,
All right,
so
thank
you're
you.
all set. You're all set for today. I'll see you soon, okay?
All righty.
Morning, sir.
Good morning,
What's your last name?
Trujillo.
So we're here today for your revocation hearing. So we're going to get started with that. Good morning. I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing for Trujillo Javier, number 392360. Today is November 26, 2024. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Can you please state for me your full name and DOC inmate number for the record?
Javier Trujillo, 392360.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better awaited evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, release you, and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge, state your PO is bringing against you. I will review and identify exhibits filed for the record. You will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
You guys sent me some documents to apply for a public defender or an attorney.
So you're saying you're requesting an attorney? Did you fill out the paperwork and send it in?
Yes, ma'am.
And you didn't hear a response yet?
No, ma'am. I just mailed it out about a week and a half ago, maybe a week ago, to 55 Farmington Avenue, 8th floor. Yeah.
It didn't go to 55 West Main Street in Waterbury?
No, I did not. It said on the paperwork.
Okay.
I should have brought it down. But I
Okay,
did.
so you sent in the application for that and you didn't hear back yet?
Yes, ma'am.
All right, so do you want me to continue you to my next hearing date? Or do you
No,
want to
it's
go
fine.
forward?
Yeah, we could go forward. It's fine.
Okay, it's up to you. Okay, so you have important rights today, the right to have an attorney. You're saying you want to continue without one?
Yes, that's fine.
Okay. You've
But
received
I just wanted to be clear, I did submit the paperwork, but I just haven't heard back. But
Okay,
I'm
well, that's
fine
why
to
you
continue without
had,
one.
okay. So you have a right to see the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am, I believe so.
It's the packet and the reason why you're here.
Yes.
Yeah. Okay. You have a right to view the evidence. You have a right to submit evidence to support your case. At this hearing, you have a right to call and examine voluntary witnesses, cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so you'll now review the charge, state your appeal is bringing against you, and the information underlying each charge. So charge 1 under release direction absconder, your charging officer reported at 7/4/24, approximately 8:35 a.m. You're observed walking out the front door of the Bishop House, your only PC residence without permission and carrying a book bag. Bishop House staff attempted to verbally direct you back into the program. However, you failed to put up a peace sign and kept walking down the street. You failed to contact Bishop House staff or your PO and whereabouts of the community were unknown. And charge 2 is travel on 10/9/24. You're apprehended in Iowa and charged as a fugitive from justice. And the state has filed the following exhibits that are pre-marked for identification purposes. As Exhibit A, parole violation notice. B is PCS conditions. D is halfway house agreement. That's C. D is Bishop House incident report. E is Bishop House discharge report. F is remand to custody order. G is parole rights, and H is parole violation report. Did you receive notice of parole violation report, and those other documents I marked, and did you review them?
Yes, ma'am.
Do you need to continue this hearing to obtain any additional evidence?
No, ma'am.
We don't have any witnesses today, so now is your opportunity to respond to parole violation charges against you. However, remember that you may remain silent if you so choose. I'm going to swear you in under oath today so you can speak. So can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, that the evidence you shall give in this case shall be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury?
Yes, ma'am.
All right, so would you like to say anything right now in regards to the violations that I read?
Yeah. So that is all correct. I did leave the Bishop halfway house on that day, and leave state lines. When I maxed out and started my special parole in 2021, I got an interstate compact to Puerto Rico where I was reporting there for about maybe 8 months. I lived in Puerto Rico for 2 years with my parents. Puerto Rico parole told me that I no longer had to see parole. I didn't have parole, special parole, and just to stay out of trouble. Around that time, me and my father were clashing a lot, and they kicked me out of the house. I had a work opportunity in Iowa, so I took it. While living in Iowa and working, one time I was making a road trip. My car broke down. A state trooper was just making sure everything was fine, ran my name. A couple of days after that, while I was at work, I received a call from Connecticut Parole asking me what was going on. I told them I was in Iowa. They said, "Why aren't you in Puerto Rico?" I told them that Puerto Rico told me I was fine and I didn't have parole anymore. They said that's not Puerto Rico's decision to make. That's Connecticut's. They took down my information where I was working. This is a parole officer, Boisvert, where I was working, where I was living, and said that he would be in touch. About 3 or 4 days later, he called me back, and in his words, he said, Puerto Rico admitted that they effed up and dropped the ball, so they were not going to violate me, but instead attempt to issue another interstate compact to Iowa, which they began the process of. Iowa took the whole 90 days that they had to accept or deny my transfer and then denied it. I was given a week exactly to relocate back to Connecticut. At the time, I tried to get a little more time because, I had a job, an apartment, girlfriend that was pregnant, a bunch of stuff going on. They told me, no, I had exactly till Friday. It was a Monday when I was issued that notice via phone. So I began selling some stuff. Me and my girlfriend lost our apartment and we drove to Connecticut, spending about $1,800 in total between gas, hotels, etc. Parole officer Boisvert told me to have my girlfriend and stepchildren call 211 in the state building to try to get them some living assistance. I would be checking into a halfway house, and then once I was there for at least 2 months, he would then get me into a reach bed. So we called 211 upon entering Connecticut Friday morning and went to the state building. They tried to call DCF and take the kids. So we spent another $3,500 flying them back to Iowa to live with her mom. Like I said, we lost the apartment upon moving here. I checked into the halfway house where immediately they gave me a hard time about driving, which was
you can't drive in a halfway house. Yeah, that's one of the rules.
Yes, that is correct. But Parole Officer Boisvert knew that is how I was getting to the halfway house. Like I arrived in my vehicle and they tried to, punish me for getting to the halfway house, complying, driving over, X amount of miles to get back to Connecticut. I drove. So with my license and a registered and insured car. They checked my bags. They told me I was allowed to smoke per Parole Officer Jackson, marijuana. Just don't bring anything in the house. They checked my bags. When I got up and I was unpacking, I found some marijuana paraphernalia. I told them, hey, I don't want any problems. Like, you guys checked my bags. You didn't see this. I don't want it in the house. I don't want to get in trouble. I don't want you guys to get in trouble. And I put it in my van because mom was coming to pick it up. They put me on restrictions. I felt like they were constantly trying to transition me back into jail when at this time I was living out for, a little over 3 years without a single new charge or violation. So I just say all that to say, I'm not the same person I was when I got sentenced to this case. I've been doing everything I can to move forward and, be a better person and contribute to society. I don't have any family out here in Connecticut left. Except for my grandmother, and she's on housing, so she can't sponsor me or help me at all with, getting out of jail. I noticed that the parole officer recommended 6 months. Mm-hmm. That's fine with me. I'm also trying to do a sentence modification because, like I said, I did more than half my time without any new charges. And yeah, I don't know. Like, my family's in Iowa now. My girlfriend ended up having a miscarriage. That's why I ultimately left the halfway house, because my first meeting with Parole Officer Jackson, she was yelling at me and treating me as if I wasn't a human being that was already doing the right thing for the past 3 years since being released and starting my special parole.
You do know that you are on special parole till 2026. No matter where you go, you're on parole.
No, absolutely. However, as I stated, when I was in Puerto Rico, they told me I was fine and I was off special parole. I signed a paper, and that's why I left Puerto Rico to go to Iowa in the first place. After Connecticut parole got a hold of Puerto Rico saying that's not your call to make, that's why I wasn't violated for that, because Puerto Rico admitted that they dropped it.
So you came back here and then you left the halfway house and then went back to Iowa?
From Puerto Rico?
After you came back here. You came back from Puerto Rico, then you left the halfway house, and then you went to Iowa again.
Yes, ma'am, that is correct. Absolutely. That's not contested. Like I said, my fiance had a miscarriage. So if you want to penalize me for that, that's fine. I'm
penalizing you for we're looking at the violation.
Conditions. Yeah, I understand that.
You can't just do whatever you want. I understand that there's a lot of things going on. Everyone's got something going on in their lives. There's always going to be something.
Yeah, I'm just, all I'm trying to say, because I have the opportunity to speak on my case, as you gave me that, is it just sucks when someone's really trying hard to do everything right and not getting
Well,
anything
the thing
going
is,
on.
you didn't do everything right because you wouldn't be here now if you did everything right. Because
You
you know
are
what I
correct,
mean?
ma'am. Can we proceed?
We're proceeding, yes.
Thank you.
But I'm just gonna say, there's a reason why you're here.
Yeah, because, yeah,
So-
you're right. Because Puerto Rico told me I was fine and then I wasn't. And then I spent my own money.
Well, you know you're on special parole and you have an end date for Connecticut.
Yes,
It
my
doesn't
special
matter
parole
where
was
you go.
transferred. My special parole was transferred. They had me sign papers saying I was done with it. And then Connecticut said, that's not Puerto Rico's call to make, it's ours, we want our time.
Correct, you're
Yes.
CT on parole and CT, so that's what matters. You're on parole until a certain date with us. Doesn't matter where you go.
Okay, see,
Alright.
I was unaware of that when they had me sign release papers.
Okay.
It's like,
Well, I
yeah,
hope it's
no.
clear now.
Yeah, very.
So what I'm gonna do, I'm going to announce my findings with respect to the charges. So on that charge 1, I find you violated the charge absconder. This is based on a warrant being issued by the VOPP and evidence that was provided in support of the charge, exhibits B, D, and E, as well as testimony. And on charge 2, I find you violated condition travel based on evidence provided, exhibits B and H, as well as testimony. So that includes the fact-finding portion of the hearing. Before I make recommendation, you'll have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So regarding to your future plans of going back out, what do you plan on doing when you go back out?
I'm gonna try to hire a lawyer and do a sentence modification or try to get another interstate compact to be with my family.
Well, so, I understand that, but as far as the release plans, you said you need housing, correct, here?
Yeah.
So what area would you want to go to?
It doesn't matter.
Is there somewhere? where you
Wherever I go,
wanna
I don't
work?
have any family in Connecticut left. That's why it does not matter where I go. I'm gonna get a job and, proceed with it. Me and my fiance's plans to hire an attorney and try to get things going.
Okay, so you don't, so if Hartford, you want to go to Hartford, or do you want Waterbury, New Haven?
Waterbury's fine.
Okay, so we'll put that district. Do you have any type of work that you're looking at doing when you get out? Any type of work you do?
No.
Is there anything else that you want to say you want to partake in when you get out, and any other plans?
No, man. Just, to get back to Iowa where I had my job at Malloy Electric, an electric motor company helping,
So you work on cars? Or-
No, electric motor company, like the motors that run dams, windmills.
Okay. So you do well in the community too. I don't know what's going to happen with your sentence modification, but you can apply to go. As long as you're compliant here for a while to go back to Iowa. So you can do that as long as just do it the right way, and then you can go there.
No, I understand that completely. It just has been a headache. And like I said, for the past 3 years, I've been, complying in every way. No new charges. I've been, contributing to society. So, it was just a shock when Connecticut gave me very little time to pull up my roots completely that I just set into the community in Iowa to get back. And then when I did that, without really any questions, I got met with a lot of hostility, is what I'm saying.
Okay. All right, so I have reviewed all the evidence that I have. I've listened to testimony today. I will put on the record, you were out there for about 3 years and 1.5 months before absconding, before you were extradited back to Connecticut, which was 10/23/24. So you were gone about 4 months as an absconder. Let's see. The warrant was issued for absconding on 8/7/24. You were brought in on 10/9/24 in Iowa. So Based on this information, I'm going to recommend that parole be revoked and you be re-paroled for March 24th of 2025. This is about a 5-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, no contact with your co-defendant, Emeritus Nieves, without PO's permission, no contact with victim BP, operation of motor vehicle. My findings are going to go to the parole board on December, I think it's 10th. December 5th, actually, December 5th. So I present this to the parole board. They make the final decision on what your re-parole date would be. So they can keep it the date that I recommended. Can you
I'm
hear me?
sorry, can you repeat? I
Yes.
heard that you said December 10th, you're gonna recommend to the parole
It's
board.
December 5th, actually. So December 5th, I'm going to present your case to the parole board, and then they're going to make the decision on when you'd be re-paroled. So they can lessen the sanction as soon as 12/5. They can agree with me 3/24/25, or they can make it longer if they want to as well. So you'd be notified about a week after 12/5. You're going to get something in the mail from the board. It's going to say what your re-parole date is if they give you one, and it's going to say your conditions on it.
Okay,
So they're going to make the decision on that day of December 5th. So you'll know about a week after.
okay, and then, if I do find, cause I do still have a few aunts, in the state that
Yeah.
are willing to like help me or sponsor me, do I just submit that to parole so it wouldn't be a halfway house placement?
Well, you're going to go to a halfway house because you need all the information right now. You can work on getting information so you can get out of the halfway house. I mean, on time.
So it's yes from the halfway house?
Yeah, I would work on that
Okay.
so you can get out sooner.
Okay,
If you have a sponsor, they're going to want to move you out. They don't want to take up a bed in a halfway house. If you're doing well, you move out and then you can work on transferring down to Iowa the right way. So as soon as you get to the halfway house, start your transfer paperwork. You can ask to start it. I'm not sure what the wait time might be. It may be a couple months out there that show you're doing well, and then apply to transfer to Iowa. Okay?
understood.
Okay. So I
Okay.
wish you the best of luck, sir, and you're good for today.
All right, have a great day.
You too. Good morning,
Good morning.
Mr. Mims.
How you doing?
Good, thanks. How are you?
Making it there.
So we're here today for your revocation hearing.
Yes,
So I have your attorney here, so we're going to get started with that, okay?
all right.
Good morning, I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Mims Donald, number 241093. Today is November 26, 2024. This hearing is being conducted via video at the BOPP Central Office in Harford Correctional Center. This is a public hearing and public access. This hearing is available via video live stream. Can you please state to me your full name and DOC inmate number for the record?
Donald Mims, 241093.
You, new counsel here today.
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Mims.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing you, place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge, state your appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present our relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background history. Do you have any questions about the purpose or procedure?
No, ma'am.
Your important rights today, the right to have an attorney present and your counsel here. You've received the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses or cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, ma'am.
All right, so now review the charge, state your appeal is bringing against you, and the information underlying each charge. Charge 1, under our bail laws, obedience law. Your charging officer reported on Tuesday, 7/2/24, Harford Police Department Patrol Division was dispatched to 110 Newfield Ave to investigate a reported stolen motor vehicle scooter complaint. The owner reported that her scooter was parked outside of her driveway at 110 Newfield Avenue during the overnight hours of 7/2/24. The owner stated that when she returned to her scooter where it was initially parked, it was missing and the keys were not inside of the scooter. The listed scooter was then entered as stolen. The scooter was then tracked down by using a Samsung audio tracking device that was installed on her scooter. The scooter was tracked down in the area of Weathersfield Avenue in Hartford, where they saw you operating the stolen scooter. Subsequently, you were arrested and charged with the following: larceny 4th, use of motor vehicle without owner's permission, and criminal trover in the 2nd. You were engaged in a criminal act and based on your behaviors in violation of standard parole conditional bail laws. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, Connecticut conditions of parole; B, Connecticut Board of Parole remand to actual custody order; C, notice of parole violation, notice of parole rights; D, parole violation report; E, Harford Police Department report ending in 6692; and F is Connecticut Judicial Pending Case Detail. Did you receive notice of parole violation report, and those other documents I marked, and did you review them?
Yes, ma'am.
Okay, and counsel has filed the following exhibit pre-marked for identification purposes as Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing containing any additional evidence? So we don't have any witnesses. I will put on the record, it is noted that the offender was convicted of use of motor vehicle without permission and given a 5-month jail sentence with all other charges nollied. And there's a EUS date of 11/29/24 on that conviction. So I'm not turning it over.
Yes, it's singular charge of obedience to the law. It's a misdemeanor, use without owner's permission, I believe is the correct charge. My client had indicated that someone had given him a scooter for him to borrow. So an individual, if my math is correct, Mr. Mims was 3 months short of being out in the community for 3 years, and he had no, according to the parole officer, no graduated interventions or sanctions during his period of supervision. Don't just go out and start stealing things after being out on supervision for almost 3 years. So I think the use without owner's permission was the appropriate charge for this particular matter. And as you indicated, he did resolve the case. It's Class A misdemeanor, and he was given 5 months, and I do concur with that EOS max date of 11/29/24.
Do you have a sentence date?
Yeah.
On that, or what day it was?
11/1/24.
All right. Okay, go.
And I want to be heard about his background at the appropriate time, please.
Okay. So what I'm gonna do next is announce my findings. So on that charge, one, I do finding violated conditional bail laws, obedience to the law, based on your conviction of use of motor vehicle without permission, and received a 5-month jail sentence, as well as exhibits that supported this charge A, D, and E. That includes the fact-finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you'd like to.
Yes, on behalf of Mr. Sims, I am respectfully requesting my client be reinstated as soon as possible. I do understand we have that court date of 11/29. As I previously indicated, my client was, I believe, 3 months short being out in the community for 3 years. He had no graduated interventions or sanctions during this period of supervision. My client is 45 years old. He does have 2 children. He was last sponsored by his mother, Miss Mims, in Harford. That is who he wishes to have as a sponsor again. Provided you her address and phone number in the document. My client did complete his GED while incarcerated. He did report to us he obtained his OSHA 10 certification and certification from Fresh Start Pallet Products in Harford. As far as work employment, you can see my client had numerous jobs while he was out in the communities, worked at Trader Joe's, Capital Work Partners, Best Chance for Second Chance program at Fresh Pallets Products, building houses. Also had a full-time job at Minority Construction Council. He's indicated to us that job is still available to him, hopefully upon his reinstatement. He worked for H1 in Manchester for about 6 months until he got the job with the Minority Construction Council. And also in the summer of 2023, had a full-time job as a HVAC technician for Reiki HVAC in West Haven, and most recently Strategic Materials in South Windsor, and that position was through Expert Staffing Temp Agency. He reported to us he did participate in outpatient programming and transitional case management, SCRT in Harford, and he's also reported to us in 2022 he did successfully complete anger management group. Previously indicated one more time, it's important to note that he was out for almost 3 years, accrued no graduated interventions or sanctions in his period of supervision. And once again, he'd like to be sponsored by his mother in Harford. And also he'd like to enroll in tractor trailing school to obtain his CDL license. As I indicated, he has been in contact with the Minority Construction Council company, and he's able to get a job there. He also applied with Empire Paving out of Harford for a job there.
Thank you. All right, so I've listened to testimony, I reviewed all the evidence from the state. So I do see that you were out there on special parole for about 2 years, 8.5 months, with no prior violations or misconducts received. Sounds like you were working and you were doing well. Unfortunately, this occurred. So based on that, I am going to recommend that parole be revoked to be re-paroled for December 5th, 2024. This is about a 5-month period of confinement as a sanction. I recommend the following parole conditions, which is the behavior management program for anger management. I know you completed it, but I'm not saying you have to do it again. I'm just leaving it on there. So my findings will go to the parole board on December 5th. If they agree with me, you'd be released that day. They don't have to agree with me. They can do a later date if they wanted to, but you should be released on December 5th, most likely.
So as I explained to you, Mr. Mims, your re-parole date and your board review date is the same day, which is a Thursday. As you just indicated, they meet in the morning. If they adopt the recommendation, you are on special parole, they have to release you on December 5th. There's an issue. If they don't accept it, I'll set up another call with you to explain the next step to you, but hopefully that's not the case, okay?
Thank you.
All right, good luck to you.
You're all set. Good luck, sir.
All right, thank you.
You're welcome.
We handle the next, or?
In regards to inmate Robert Shepard, number 266562, revocation hearing has been continued to December 10th on request of counsel. Good morning. I just need Mr. Grant today. Mr. Shepard does not have to appear.
Thank you.
Mr. Shepard, you're continued, right?
Yes.
Your attorney will be contacting you, okay?
Yes.
We'll see you on December 10th.
Okay, thank you.
Yep. Good morning, Mr. Grant.
Yes, good morning.
Good morning. We're gonna get started in 1 minute, okay?
No problem.
Are you available to do an escort, high security, video conference back to echo?
The number you are trying to call is not reachable.
Come back, can you just grab this, I'm about to press something to the LT, can you just bring it to
Hi, this is Theo Gerard.
Morning, this is Parole Officer Meisinger, how are you?
I'm doing well, thank you. How are you?
Good, I just received your message. We are live streaming with Mr. Grant right now, and we have attorney Sirica here for this case. So are you all set to begin?
I am, thank you.
Okay. Good morning, I am P.O. Meisinger, a hearing examiner for the Board of Paroles and Paroles. This revocation hearing concerning Grant Tevin, number 371813. Today is November 26, 2024. This hearing is being conducted via video at the BOPP Central Office, New Haven Correctional Center. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state to me your full name and DOC inmate number for the record, sir?
Yes, Tevin Grant, 371813.
And we have a parole officer present. Can you please identify yourself for the record? Theo Gerard, are you there? Hold on 1 second.
Call has been forwarded to an automatic voice message.
So I'm just gonna pause the record. I'm just trying to get a hold of your PO. Just give me 1 second.
No problem.
Hi, this is Parole Officer Gerard.
Hi, PO Gerard. Sorry, I think we lost you.
Yeah, I don't know what happened, but I'm here. Thank you.
Okay, perfect. So I'm gonna go back on the record. Can you just say your title for the record?
Sure, State of Connecticut Parole Officer Robert Gerard.
Thank you. We have counsel here today. Please identify yourself.
Sure. Attorney Alfonzo Sirica, public defender with the Parole Revocation Unit, on behalf of Mr. Grant.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, The better read of evidence must establish that more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing you, place you back on parole supervision. If I find you violate one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charges, state appeal is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
Okay. Your important rights today, the rights to have an attorney present, you have counsel here. Your right to receive the written notice charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights? Are you ready to move forward?
I do.
Okay, so we'll now review the charge. State your PO is bringing against you and the information underlying each charge. So PO Gerard, if you could please read the charge.
Sorry about that. I wasn't ready for you.
That's fine. I can always read it if you don't have it up.
Yeah, I believe the charge was threatening in the first degree.
So I'll read it for you. So charge one is under obedience to the law. You're charging off support at 9/24/24 at approximately 8:10 p.m. You were called to Supervisor Alexandria Payne's office. She asked you for your discharge paperwork from the hospital. You told her you did not have any discharge paperwork. Supervisor Alexandria Payne then instructed you to go to the front office to see COD Rayner so that he could give you a breathalyzer. You asked her why you need to take a breathalyzer. She explained to you that it's the halfway house protocol to render a breathalyzer in urine on anyone that is returning from the hospital. You then walked out of her office and said, fuck this place up, blow this place up with all the staff in it. Supervisor Alexandria Payne asked you if what you said was a threat, and your response was shut up, you're emotional. Supervisor Alexandria Payne then told you that she does not take threats like this lightly and that she was going to report it. Halfway House staff contacted 911 and Waterbury Police responded to the Halfway House. And upon the conclusion of the investigation, based on the facts and circumstances, you arrested in charge of violation of the following General Statute 53A62, threatening in the second degree. This matter is still pending in GA4. And the state has filed the following exhibits pre-marked for identification purposes as Exhibit A, notice of parole violation. B, notice of employee rights. C, remand to actual custody. D, PCS signed conditions. E, DOC halfway house agreement. F, DOC incident report. G, Waterbury Police Department incident report 0619. H, parole violation report. And I is CT judicial case lookup. Court date 10/18/24. Did you receive notice of parole violation report, and those other documents I marked? Did you review them, sir?
Yes.
Okay, and counsel's file following exhibit pre-marked for identification purposes. Defense Exhibit 1, which is list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence? We don't have any witnesses today. I will put on the record, the addendum states that we have received that on 10/18/24, you were convicted of threatening second physical threat and received an unconditional discharge for that. So at this time, the state will have an opportunity to present any evidence and speak if they'd like to testify. I'm just going to swear Mr. Grant as well as P.O. Gerard. I'm going to swear you both in case you both want to speak today. So can you both raise your right hand for me, please? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give in this case should be the truth, the whole truth, and nothing but the truth to help you God about penalty of perjury.
I do.
Okay, so P.O. Gerard, would you like to say anything at this time in regards to the charge?
No, not at this time.
Okay, so now I'm gonna turn it over to defense if you'd like to say anything. At
Yes,
this time.
during the first part of the hearing, that is the correct addendum. My client, it was a misdemeanor charge, threatening in the second degree. And I believe he only went to court once or twice. The case was resolved within, I think, 3 or 4 weeks on October 18th of 2024. He did receive an unconditional discharge. in J4. That was my brief comments regarding the first part of the hearing. I do want to be heard about his background at the appropriate time.
Okay. So what I'm gonna do next is I'm gonna announce my findings. So on that charge one, I do find you violated conditional bail laws, obedience to law based on your conviction of threatening second physical threat and received a sentence of unconditional discharge. So that includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose of this part of the hearing is to help determine what outcome I will recommend. So at this time, Appeal Jar, would you like to make any statements at this time?
No, at this time, no. I had only taken over the Central Ave halfway house about 3 weeks prior to this incident, so I haven't had very much interaction with Mr. Grant at all.
Okay, so this is the only time that you'd be able to speak? So nothing else, nothing further?
Well, yeah, I could say that he absolutely violated his, halfway house agreement with threatening to blow up the building, and I guess that would be all.
Okay, thank you. Great, turn over to counsel.
Yes, on behalf of Mr. Grant, my client is 32 years old. Upon his release to supervision, he was at that Connecticut Renaissance halfway house. So he was remanded. He did report to us. It's like in 2013, did obtain his associate's degree in criminal justice at SA College in Brooklyn, New York. He was also recently attending Manufacturing Alliance Service Corporation School in Waterbury, where he studied manufacturing, engineering, and CNC machinery. He did complete about half of the program there. Also received various certifications through the Department of Labor and CPR, first aid, small tools, small engine, and he has the OSHA 10. Has construction and heavy equipment experience. Was not working while in the halfway house. The difficulties of him getting passes to leave, but since he's been incarcerated, he does work in the facility. In the kitchen and also doing detail every 7 days a week. He'd like to be placed in a halfway house in the New Haven area. He's looking to get a fresh start in a different community. He's amenable to any job opportunities he can take, potentially turn into a career. Also did indicate to us it was at the Renaissance Central. He did participate in mental health evaluation and successfully completed anger management programming. So my client, he was out for approximately 7 months. He did receive an unconditional discharge in court. So I am asking to have my client reinstated as soon as possible. Thank you.
Thank you.
And may I add, subject to always being correct, I'm showing this is his first violation.
Yeah.
As far as his supervision. Thank you.
So I have reviewed all the evidence submitted by the state. I've listened to testimony today. I will put on the record, the offender was in the community for about 7.5 months before being returned to custody for this incident in the halfway house, which resulted in a new conviction with an unconditional discharge. So based on this information, I'm going to recommend that parole be revoked and that you be reparoled for December 23rd, 2024. It's about a 3-month period of confinement as a sanction. And I recommend the following parole conditions: halfway house placement, no contact with your co-defendant, Tyrese Blue, no contact with your victim, DC, DM, and BR, mental health evaluation and treatment as deemed necessary, as well as behavior management program for anger management, which I am requesting that you retake that program for anger management. My findings will go to the parole board on December 5th. So the board's going to review this case and they're going to make the final decision on what your parole date would be, your reparole date. They can make it longer if they want to. If they wanted a later date, then you come back before the board and talk to them. Or they can agree with me or let you out as soon as 12/5. Do you have any questions? You understand?
Copy.
Mr. Grant, if you call our office the next day December 6th. One of my secretaries can tell you over the telephone if they've adopted the recommendation, and if they do, you'll be released on 12/23.
Yes.
Okay,
All right.
okay, you're all set. Thank you, P.O. Gerard.
Thank you.
Have a good day.
Had they not even called him down?
I'm not sure. They just said he'd be right there. Good morning, sir. Mr. Scott?
Morning.
Good
Hello.
morning.
Morning. Morning,
Um,
Rob.
So
Hey.
we're here today for your revocation hearing, okay? We're gonna get started with that.
Okay.
Good morning, I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This revocation hearing, Sir Scott Jahki, number 404694. Today is November 26, 2024. This hearing is being conducted via video at the BOPP Central Office in Garner Correctional Institution. This is a public hearing and public access to this hearing is available via video live stream. Can you please state for me your full name and DOC inmate number for the record?
Jahki's got 404694.
Thank you. You have a parole officer present. Can you please identify yourself for the record?
Parole Officer Kimberly Goodman.
Thank you. We have counsel here today. Can you please identify yourself?
Yes, Public Defender Robert Famiglietti of the Public Defender's Office.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, releasing you, place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charges state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure?
No.
Okay. Your important rights today, the right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
Okay, so we'll now review the charge the state appeal is bringing against you and the information underlying each charge. I will note that charge 2 GPS is not taken in consideration as no finding was made at the time of the prelim. So P.O. Goodman, if you can please read the remaining charges.
Yes. Are you guys able to hear me okay?
Yes.
Okay. Reporting. On 8/29/24, you failed to report to your parole officer as instructed. You were instructed you were to report to the DDS-TU program, and your PO would meet you at said program to complete your intake and GPS install. Parole and Community Services officers met with you 2 weeks prior to your VTP to review your release plan and reporting instructions. You were also given written instructions at the facility with reporting instructions. You refused to sign the instructions and refused to sign the release from custody and be transported to the program. Because of your behavior, you were in violation of special condition number one, special parole condition number 1, release direction reporting. Program participation. On 8/15/24, P.O. Spinelli and P.O. Goodman met with you at Garner CI and instructed that you would return to your previous court-ordered DDS program, which involved placement in the treatment unit program. At such time, you informed P.O. Spinelli and Goodman that you would refuse placement in the program on your release date. We reminded you that you are court-ordered and involuntarily committed to the program via probate court. You informed us you would still refuse. On 8/29/24, you refused to be released and transported to said program. You failed to participate in the program as instructed by parole in the court. You are in violation of special parole condition number 1, release direction programming. Residence. On 8/29/24, you refused to be transported and admitted to court-ordered residence, the DDS Treatment Unit Supportive Housing Program. This was your only parole-approved residence. Because of your refusal, you are in violation of Special Parole Condition 1, Release Direction Residence. Under Obey All Laws, legal obligations. On 8/29/24, you refused to be released on special parole and transported to the DDS-TU program. You are probate court ordered via involuntary commitment to reside and participate in said program. As a result of your behavior, you are in violation of special parole condition number 2, Obey All Laws legal obligations, as you failed to fulfill this obligation to the best of your ability.
Thank you. And the state has filed the following exhibits pre-marked for identification purposes as Exhibit A, parole conditions, current and previous. B is remand to actual custody order. C, notice of parole violation, parole rights. D, parole violation report. E, release authorization reporting instructions. F, GPS monitoring agreement. G, offender letters. H, emails. I, probate decree. J, prior revocation summaries. And K is audio recording refusal to be released. And did you receive notice of parole violation report, and those other documents? And did you review them, sir?
Yes.
Yes,
Okay.
we have.
Okay. And counsel has filed the following exhibit that is pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement, and Exhibit 2, which is offender program eval. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
We do not have any witnesses. So at this time, I'm going to swear in Mr. Scott as well as P.O. Goodman, so that if you do choose to speak today, please raise your right hand. You solemnly swear or solemnly affirms the case can be the evidence you shall give turn this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
I do.
I do.
Thank you. So at this time, the state has an opportunity to speak regarding any evidence submitted at this time. Would you like to testify today, right now, regarding the charges?
I think currently the charges speak for themselves, but I will testify later.
Okay. So it's now a defense opportunity. If you'd like to speak to any of the evidence submitted regarding the charges at this time.
Yes, I think there are some legal concepts that are going on here that I think are very interesting. My client has a conservator of the person for a reason. And if in fact this is an involuntary commitment, I don't understand why he wasn't just taken. If it's an involuntary court-ordered commitment, whether he signed the paperwork or not, I don't think it was his choice. That's one legal argument, that he shouldn't even have been given a choice to be brought. Another legal argument that flies in the face of that is that this isn't behavior while he was on parole. And another argument is that this isn't even behavior, it's a choice. He made a conscious choice. If in fact he's able to make that conscious choice for himself, And I go back to my first two arguments. One, this is an involuntary commitment. And two, he has a conservator of the person that should be notified when he's making these choices. On that date and time, if he can make a choice, argumentatively, he made that choice. And so he didn't fail a report, he didn't fail GPS, he didn't fail programs, he didn't fail residents, he didn't fail any legal obligations because he had none. He made the choice. He's been sitting in jail as a result of his choice. It doesn't violate his parole. He just had to sit in jail instead of being placed somewhere else. There's a court order that says he has to be placed where DDS tells him to be placed. Now, that's being fought by his attorney right now. There will be a hearing on December 18th. And on December 18th, his attorney, who I've spoken with, and his conservator that I've been speaking with, are going to argue that he shouldn't be placed by DDS, that he can be placed somewhere else. I've spoken with my client. He wishes to be placed anywhere right now, anywhere they can place him. He's willing to go to the DDS placement today. So that choice he's willing to make. He shouldn't be sanctioned. These aren't violations of parole. He shouldn't be sanctioned for a choice that he had every right to make, or arguably he had no right to make. So I don't believe by the preponderance of the evidence any of these are met, and he should be released today to the DDS placement or someplace there. Even if there isn't a placement today, that's not his fault. That's their rule. That's their job to place him somewhere. Thank you.
I just want to say that I'm not quite sure when he was conserved of person. We've never been notified that he was conserved of person. I am aware that he has a guardian. Her name is Pam, and I can't pronounce her last name appropriately, so I'm not going to try. And we have been in contact with her, but she has no authority over him legal, like she doesn't sign his legal paperwork and she doesn't make decisions for him. I am familiar that there is a court case that his attorney scheduled for the 18th of December, that his attorney is requesting that the involuntary commitment to DDS be removed. Obviously, that hasn't happened yet, so the court order still stands. There was a status hearing on October 16th where the court did make a finding that the involuntary commitment should remain intact. So that the next court case is a follow-up to that status hearing where I believe Mr. Scott's other attorney submitted a request to the court for that to be removed. Parole and Community Services has the obligation to uphold the court order. We can't go against what the court has decided in terms of where Mr. Scott should be placed or lives. That's not in our purview. We're just trying to follow the court order.
So that's one of my claims, is why wasn't he placed? If they're just trying to follow the court order, he should have been placed. And so he's not violating his parole. He's not violating his parole. So where he's placed is a separate issue, and what's going on in probate is a separate issue. He wishes to be placed today, as he did not wish to be placed when he didn't sign this paperwork. And so all that's changed is he's decided that he'd be placed, and he's willing to cooperate with being placed. He shouldn't be punished for making that choice, even if he should not even been given that choice, whether he has a conservator or not. The court has ordered him placed there. All we're asking today is that we do exactly what we should have done, give him another chance to sign the paperwork and be placed there today. Let's let the court decide what they're going to do on the 18th. If they decide that he stays placed where DDS wants him. That's all I'm saying. I don't believe it's a violation of his parole. It's not for us to decide where he should be placed. It's for us to decide that he be placed instead of being in jail. I don't think a jail is an appropriate place for him. He doesn't think a jail is an appropriate place for him. He's learned, and in our report it says he's willing to be placed anywhere and will cooperate and will sign. I don't think a failure to sign, if you don't want to go to that placement, is a violation of your parole. Thank you.
All right, PCS, do you have something you were saying?
Yeah, just as the last letter he wrote to the director's office and the supervisors is that he was unwilling to be placed back in that program. So I get conflicting information because we have documentation which I submitted into evidence on multiple occasions that he's refusing to go back to that program. I physically, I believe the facility cannot forcibly remove somebody and drag them into a van and then transport them to a program unless there's a court order to do so. And we didn't have a court order to do that, the facility nor Parole and Community Services. So I understand exactly what you're saying, Mr. Famiglietti, but that wasn't an option at the time.
All I'm saying is it is today.
Well, I don't know where DDS stands. There's no documentation, at least that was provided to us, that there's availability at the program that he's court ordered to.
That's up to DDS to decide to place him somewhere else. That is not an issue today.
Mm-hmm. It still doesn't change the fact that he committed
where someone would be. We're getting awry here, but
well, is there anything else in just regards to the violation itself? Because we can talk about this on the second part if we want to talk about that. But so I'm going to be right with you with my findings. Right, so I'm going to announce my findings, and I had previously stated charge 2 GPS is not taken into consideration today. On that charge 1, I do find you violated condition reporting based on the evidence that was provided, which is exhibits A, E, H, I, and K. Charge 3, I find you violated condition program participation based on the evidence that was provided, A, E, H, I, and K. On charge 4, residents, I find that you violated that condition based on the evidence that was provided, A, E, H, I, and K. And charge 5, I find you violated legal obligation based on the evidence provided, which is A, E, H, I, and K. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. This purpose part of the hearing is to determine what outcome I will recommend. So, P.O. Goodman, would you like to say anything in regards to this part of the hearing?
Yeah, sure. I just, this is Mr. Scott's 4th violation on this period of supervision. He's absconded multiple times from multiple different settings that he's been in. He continues to display some behaviors that put him in the situation with his instant offense in the first place. He has 3 disciplinary tickets, 1 for fighting and 2 for sexual misconduct. He was unsuccessfully discharged, and it's in the evidence from problem sexual treatment services. And he does not take ownership for his crimes. He's high risk in terms of the fact that he's not only supervised by the mental health unit and a mental health parole officer, but he's also supervised with an officer out of the sex offender management unit. And he continues to display a blatant disregard for the conditions of his parole and his legal obligations to the state of Connecticut. He still owes the state of Connecticut 2 years, and his parole was granted on the premise that he could remain at liberty in the community, and that premise is no longer valid. He's creating other victims, and his behavior is unacceptable. And he continues to write letters and refuse to participate in court-ordered programming and residential placement. And there's more letters than what was already submitted into evidence. So I find it very convenient that Mr. Scott has come here today saying he's willing to go when he's been writing letters since prior to his reinstatement date that he's refusing. And the first attempt that he had to take off from that program that he was in previously, which he was violated on for absconding, The first attempt, first opportunity he had, he took it. He's previously been found in possession. He's a registered sex offender of pornography while out in the community, even though he's stipulated not to have in his possession any pornography. I'm not sure how many times he has to violate before we figure out that he's not going to comply with the conditions of his release. He's already served a 9-month sanction for absconding and a 5-month sanction for absconding.
Thank you.
Thank you.
Defense, would you like to say anything at this time?
Yes, that's all my clients passed. That's not what we're dealing with here today. We're dealing with his choice that he didn't want to be placed in the DDS placement. And that's why his attorney has filed a motion, because he didn't want to be placed in that facility. This is not a normal parole violation. This isn't misconduct. This isn't dangerousness to society. This is not him taking another illegal act. This was a conscious choice that he didn't want to be placed there, and he thought this was the only way, because his attorney hadn't filed the motion yet, and he's been asking his attorney for a lengthy period of time to file that motion. Finally, the attorney has gotten around to file the motion. But my client has a right not to want to be involuntarily placed. He's got a right to say that. And that's what he was trying to do. He wasn't trying to violate his parole. He wasn't trying to manipulate anyone. He was trying to stick up for himself. He did not go to any counseling. That wasn't his intent. His intent wasn't not to go to counseling. His intent wasn't to not report. His intent wasn't to not go to programming. We have to look at his intent here. We shouldn't sanction him for him making a legal decision. We shouldn't sanction him for him saying, oh, I just don't want to be placed there. Now he's changed his mind. He understands, okay, if I don't want to be placed there, I'm just going to have to sit in jail. So the decision is for him to be placed there. That's what the courts have decided. We're not here to decide that that's a wrong decision. That's the right decision to place him in the community. Now he's willing to go along with that. We shouldn't punish him for having taken a legal position. Thank you.
Thank you. Is there anything else from?
No, I know you've read our reports. I know you've seen the latest report of him doing very well in the work performance and evaluation. I know you've seen Exhibit 2. He's doing very well when he puts his mind to it. And he didn't want to go to the other place, but when he puts his mind to it, he does well.
All right, so I'll be right with you with the recommendation. All right, so I will put on the record that this is a third violation. There was a process failure, but there was 2 prior absconding violations.
Can I just put on the record too, though, while there was a process failure, that didn't mean the behavior didn't happen.
Okay, noted. So the offender does have 6 years special parole. He's on special parole till November of 2026. So based on this information today, I'm going to make a recommendation that parole be revoked, that you be re-paroled for June 27th of 2025, which is about a 10-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, mental health evaluation and treatment as deemed necessary, no contact with minors without PO's permission, problem sexual behavior treatment, general no contact with address of 6 Woodside Ave, Danbury, Connecticut, no contact with victims DL, JB, and AS. My findings are going to the parole board on December 5th. So the board's going to review this. The board can agree with that. They can make it less sanction, or they can make it longer if they like to. You would know, you can talk to your attorney on December 6th and find out if you want what happens, or later that day. I just hope everything gets resolved, because if you do get approved and you still have this order, if you don't want to go to the program again, you're going to remain in jail and probably not go back out until you're done with your sentence. So I just wanted to give you the opportunity, sir, to think about what you want to do before, you get another option to come out again. So you need to think about that and make sure everything's.
Can I just make it clear on the record too that I
Yes.
understand that you added the condition of halfway house placement? Can we just make it very clear on the record that that's if he's placed in a halfway house? If the involuntary commitment is not lifted, then we still have to go by the court order. That's only if the order is lifted.
Yeah, no, that's just on there because I don't have sponsor information for him because he would be going to the facility. So that's just in case something happens.
I understand, but part of the documentation that he's been sending is that, in his last hearing, the last hearing examiner put a condition for halfway house, and that his premise is that he should be going because that's what P.O. Saunders said.
That's not why that's on there. That's on there in the event that something happens where, with your court case and everything you're going, or your motion you're filing, if something happens, that's on there in case of that. But if you're ordered to the program, you're ordered to the program. That the halfway house stipulation does not mean you're going to a halfway house. So just to be clear on that.
Do you understand that, Jahki?
Yeah, I do.
The court order controls.
Yes.
And what the hearing examiner just said, as your parole officer was explaining, is they have to have a fallback provision, a net. So if everything falls through, she has to say, the hearing examiner, has to say, if there's no order in effect, this is what the board would wish to happen. You understand that?
Yeah, I do.
And the final decision is still up to the local parole officer. Do you understand that?
I do.
Okay, so even if they say halfway house, if the order goes away and you come up with something else, they'll consider it. Okay, this is just a fallback. You understand that?
I do.
So in the future, what we don't want is for you to say, well, look, they said halfway house, I want to go to that's not a court order. Do you understand that?
I do.
Okay.
Thank you, sir. I appreciate you clarifying that for the record.
You're welcome. I just wanted to, make sure I went over it with him.
Yeah.
No, I
Okay,
appreciate that.
so call me on the 6th, Mr. Scott, and I'll explain to you what the board decided.
Okay.
Thank you.
All right. So you guys are all set for today. Thank you very much.
Thank
Happy
you.
holidays.
Have a good
Have a good
Thanksgiving.
day. Have a good Thanksgiving.
Thank you.
All right. So, hey, thank you guys for tuning in. This event has ended. There is another one that took place today that I'll go ahead and play. And like I said around here, life's like a candle. Once you blow it out, it lights out. And with that, we are out. A rato.